Well, good afternoon, everyone. Thank you so much for joining us. My name is Aaron Baer. I am the president of Center for Christian Virtue. Here to just give you a quick update on where things stand. It has been an amazing season here at CCV. Some of you joined us just recently here in Columbus for the March for Life. And we had thousands upon thousands of people, no matter what the media might have said, with us over at the State House. I should say some folks in the media, others covered it very well. But it's been a very busy season, partially also too because it's election season. I know some of you have gotten this in the mail. We are sort of full blitz right now with our Rise Up tour at Center for Christian Virtue, sharing these voter guides, getting them out to churches. A lot of what we're going to talk about here today is going to come back to these voter guides and talking about how important it is for us to vote. But we do want to, but there's so much going on to update you on. And we decided to do this live stream with you for two reasons, for two major issues that have been developing that we've been getting a ton of questions about at CCV. The first is the heartbeat bill. And so many of you through the years have been praying over the heartbeat bill, working, voting for lawmakers and talking to them about the heartbeat bill. And you might have just seen that it was just blocked in court. And so we wanted to bring on a good friend of the organization, Brian Fox, an attorney in Cincinnati, to talk about what's actually happening with the heartbeat bill right now. Are abortions happening in the state again after a heartbeat is detected in an unborn child? So we're going to dive into that in the first half hour. The second half hour, we're going to talk with our policy director here at CCV, David Mahan, to talk to him about what just happened at the state school board. Some of you have been really involved in issues at the state school board, especially in this last run with a resolution that came up regarding a policy that the Biden administration put forward with Title IX. And you saw some headlines there. And so we wanted to take some time to update you. There's been there's so much going on. I'm sure if you're on the CCV's email list, you're seeing everything that's happening. But we wanted to, on these two issues in particular, really unpack those for you. So we're going to start actually first with the heartbeat bill conversation and just update you on that conversation. And I want to bring in our good friend, Brian Fox, here for this conversation. Brian, last time he was here with us on these conversations was delivering good news about Roe v. Wade being overturned. This time, Brian, not so exciting news, but I think there's a little hope at the end. How you doing, Brian?
I'm great. Thanks for asking.
So Brian, like I said, last time you were here, Roe was overturned, right? And we were able to, the heartbeat bill went into effect, and we were able to ban abortion in Ohio once a heartbeat's detected. And now all of a sudden, we're seeing the courts have blocked, a lower court has blocked Ohio's heartbeat bill from our ability to ban abortion in Ohio. I thought the courts already ruled on this. Can you help folks understand what's actually happened with this court case here?
Sure. Well, I don't think that this experience was one that is entirely unexpected. As the United States Supreme Court overturned Roe v. Wade, and in effect, what they did was finally level the playing field. A phrase that Justice Kavanaugh kept using during oral argument was that the court was going to be scrupulously neutral in its approach to pro-life and pro-choice issues, arguing that the fundamental trust, the level of trust that folks placed in the Supreme Court would be enhanced if the court actually began to step aside on political questions. And so now they in effect turned that issue over to the states, and the state of Ohio passed a legislative enactment known as the heartbeat bill, which is now what is being litigated. The merits of our Ohio state constitution now find themselves being litigated in a state court, the Hamilton County Court of Common Pleas for now. And then that will make its way up to the appellate court, undoubtedly, and then ultimately the Ohio Supreme Court.
So, Brian, for folks here who aren't very familiar with courts, then essentially we've overturned Roe in one area, and now there's whole other areas of law that they're suing under. Is that what Planned Parenthood and the ACLU have done? So this almost, I don't want to say has nothing to do with Roe necessarily, but Roe is not factoring into or at least the Dobbs decision isn't factoring into the arguments that are being made in this situation.
Yeah, that's right. It's a different body of law fundamentally that's being litigated. It's the state of Ohio's heartbeat bill, the merits, the constitutional merits under the Ohio State Constitution, under our state conceptions of fundamental justice and liberty. That's what is being litigated now in the state courts. The federal courts are going to always be dealing with, obviously, federal law and the United States Constitution. And now what the folks at Planned Parenthood and the other folks that are contesting are seeking to do is they're trying to litigate the merits of whether this heartbeat bill is constitutionally violative of the Ohio State Constitution.
Gotcha. So they're suing to make an Ohio Roe v. Wade, right? So we overturned.
In effect, yeah.
Yeah. Effectively, they're looking to say you can't ban abortion in Ohio now. Brian, can you one of the things, the questions I got early on was, how in the world is one county court, Hamilton County, blocking the heartbeat bill all across the state right now? How and why Hamilton County? Why is this in Hamilton County in particular?
Well, that's a great question. Really, what the litigants involved in this case have done is they've forum shopped. And by forum shop, I mean they've looked for a court that they thought they might find a friendly ear to hear their side of the case. They originally filed, there was kind of a procedural mess in this case because they filed in multiple forums, and then they ultimately sought relief in the Hamilton County Court of Common Pleas. It's hard to discuss this without talking about the politicization of the courts, and to not go into a realistic fact of this, which is people who are running for judge come from a political perspective in the state of Ohio. And some states, judges are appointed. Doesn't make them less politically partisan, but it does change it a little bit because they're not elected every 6 years in the Ohio Supreme Court. So it's a different sort of thing. In the federal court, they're appointed for life. So a judge is typically going to be appointed by a Republican administration or Democrat administration, and those folks will then be appointed for life. In Ohio, you are on the ballot. And if folks have been paying any attention to Hamilton County of late, they know that Hamilton County has lurched left, far left of what it used to be. It's hard to win a countywide race in Hamilton County, Ohio, if you're not a Democrat. They found a compassionate court here and a well-educated. I will say this about this judge: if you read his decision on the injunction that banned, the enforcement of the heartbeat bill, it's well written. It is. He is central casting for the type of judge that folks who are seeking to challenge the heartbeat bill would like to find in a state court judge. Because, he's got a great bio, he's well educated, great law school, and he wrote a very well reasoned from their perspective opinion. So the question, why is it effective statewide? Well, it's a state statute that is being challenged, and so I think most of the people across the state are just looking to this Hamilton County Court to see what this court is going to do, and mainly because there are only so many folks who are interested in pushing the envelope as well. And so, if you're the Attorney General for the state of Ohio, for instance, you're trying to enforce the heartbeat bill statewide. If it's being blocked by a judge in Hamilton County who's issued this injunction, this preliminary injunction, that they're trying to turn into a permanent injunction. That hearing is in early December. Then you effectively stop enforcing it in Hamilton County, but also across the state, because you are concerned with enforcing a law that is potentially violative of the Ohio Constitution.
So basically here, Brian, as somebody who's from Trumbull County and now lives in Franklin County, I have you to thank as somebody who lives in and around Hamilton County.
Hey, hold on. Wait. I am in Butler County,
where
where it's a vastly different political situation,
Okay.
and as are all of the surrounding counties around Hamilton County.
Okay, that's good. That's good. Well, and I would just want to say for our viewers and listeners, if you have a question, please put it into the chat box, and I'll be able to get those from there. Claire will drop them over to me, who's producing this for us, and I can pick those up from there. So if you have a question for me or Brian, go ahead and drop it in the chat, then I'll be able to get those from you. So Brian, you talked a little bit about the arguments. In a nutshell, what is Planned Parenthood and the ACLU arguing here? And let me just start there, and then I'll commentate on my thoughts on those arguments. But what are they trying to convince the courts of?
Well, so they filed for an injunction, and procedurally, you can, you file a lawsuit, and in order to prevail on a preliminary injunction, an injunctive relief is considered an extraordinary remedy. And so you have to prove a number of factors. The most important factor, which is that the plaintiffs are likely to prevail on the merits. Yeah. And so what they are trying to prove is that the heartbeat bill, as enacted, even with its exceptions, it violates the Ohio Constitution. I mean, that's the simplistic way of describing it.
Yeah, and this is, what I'll say is, I remember I spoke to the media when this case was first filed, and this is my commentate. I'm not an attorney; I don't have to appear in front of these judges, so I can get a little punchier at times. But my thing with this case is they're really taking a concoction of disjointed phrases from the Ohio Constitution, and mixing them together in some type of word salad to come out with some right to abortion. The thing about their argument that they made in particular that was almost offensive to me is, we've been working for years now, decades in Ohio broadly, even before my time at CCV, to regulate and prohibit abortion in the state. And we've never heard anybody come and testify at the State House from Planned Parenthood or the ACLU and say, you don't have the authority to prohibit abortion under state law. This is a new thing that they are attempting to do right now. And again, I think just like Roe, any honest and straightforward look at the state constitution, you look at the U.S. Constitution, you're not going to find abortion or the concept of abortion anywhere. You're not going to find that in the state constitution. But when you combine a bunch of either existing rights or imaginary rights as they have, that's sort of the way they're going about this. So Brian, you've mentioned they're going to be moving for an injunction, a full injunction of a permanent injunction of the heartbeat bill. But timeline wise, where is this case right now, and when is it going to actually end? When would we get final word? When does this actually end up at like the state Supreme Court or something like that?
Yeah, so that's if I had a crystal ball, I would tell you. What I know is that they are, I believe the hearing is set for December 13th on the question of whether a permanent injunction against this law's enforcement ought to be issued. And so after that, then presumably the parties will appeal. I think we know where the case is going, by the way. That's one of the things that procedurally, when a judge issues a preliminary injunction, you almost always know that the other side of that is that they think that the plaintiff has pretty much proven their case, right? So they've already forecasted what's going to happen. So they'll have the permanent injunction hearing. Then a decision will be issued by that judge. And then once that decision is issued, the parties will have an opportunity to appeal that to the First District Court of Appeals. I would anticipate that the First District Court of Appeals is likely to affirm that decision. And that is because, again, we like to think that judges are neutral arbiters of the law. And I think in large part they are, but there are some questions that are so fundamental to us, to who we are as people, how we see the world. Do we see a baby? Do we see a clump of cells? One of the things that I found interesting in the case that occurred during the Dobbs oral argument was that there was a science-based argument being advanced by both parties, right? In the Dobbs case, you had the folks who were trying to defend Roe, arguing the benefits that Roe and Casey had provided for women as being able to be stronger economic participants in society since that happened. So they were including, Nobel laureate economists, prize-winning economists who were making these arguments. And so many on their side would say they were making science-based arguments. And then there are folks that are obviously on the other side talking about, the viability question and talking about, well, what is this? What life are we protecting? So I guess that's a long way of saying it'll be interesting to see what happens at the first district. I guess it's possible the first district could depart from the analysis provided by the trial court judge and overturn that decision. And if that was the case, then that will guaranteed will be appealed to the Ohio Supreme Court, regardless of what happens. This thing, I believe, is going to the Ohio Supreme Court.
Yeah, and I'll say, Brian, to again piggyback on that. You used the phrase forum shopping before. I don't think in that consideration of where they filed this lawsuit, they didn't look at the Court of Appeals they were in, and the nature of those courts, and their likelihood of success in those courts as opposed to other courts of appeals. And so, I think you're right, that that this is going to end up at the state Supreme Court, and ultimately they're going to have to be the ones to decide whether there's a right to abortion in the state constitution. I will say I see one question in from Pamela, and again, this is my interpretation of things, to be really blunt about it. But what the question is, why can't we prove there was never a right in the state constitution for abortion in the first place? And I would say, if you read what Attorney General Dave Yost and Solicitor General Ben Flowers filed and argued in the state Supreme Court, or rather in the Hamilton County court case, that is what they argued, and I think they argued that really well. The question is, what's the judge think? And I think even for those who were in the courtroom that day, you had a judge who was predisposed to coming up with a ruling to block the heartbeat bill, and so you can only get as far as your judge would allow you.
I would offer to that, Aaron, that this is not just the litigation did not center, or at least the judge's analysis in the case, in the Hamilton County case, did not center on a broad concept of life and viability, but rather, and this is why it's important to be thoughtful when you are advancing certain legislative decisions. The analysis centered on Article 1, Section 21 of the Ohio Constitution, which was enacted in order to combat Obamacare. There's a couple of provisions. One says that no federal, state, or local law or rule shall prohibit the purchase or sale of health care or health insurance. And then subsection C to that says no federal, state, or local law or rule shall impose a penalty or fine for the sale or purchase of health care or health insurance. So it is a question of what constitutes health care, right? Under state law, is abortion health care? I mean, that's almost the question. And obviously there are science-based arguments that we would make to say that abortion is not health care because you're effectively ending a life. And then there are folks on the other side that would say, yeah, of course it is, because a woman's right to make her own medical decisions.
Yeah. So Brian, this kind of moves from the realm of the legal to the realm of the political, but I see a question here from David, who is in Hamilton County, who's for voters who are concerned about what's happened to the Hamilton County courts, what can they, or what that this was chosen to go to the Hamilton County courts, what can they do as citizens on something like this? What is important for them to be doing right now?
To pay attention to who you elect to be a county judge. So pay attention to your common pleas judge, races. Pay attention to your appellate court races, and for the love of God, pay attention to the Ohio Supreme Court race, because again, that's where this will ultimately be decided. And so if folks who arrive in those seats and who wear those robes and who wield those gavels believe that the world looks a certain way and they don't share your worldview, then I would highly recommend that you look for other candidates.
Absolutely. So, Brian, let's talk about that Supreme Court. And can you talk a little bit about how many that we have an election coming up on November 8th? Obviously, that's why we're talking so much about voter guides right now at CCV, and the importance of folks turning out to vote. Can you talk about the makeup of the Supreme Court right now, and what we'll be deciding on November 8th? And then we'll talk about how that all plays into this conversation around the heartbeat.
Yeah, there are three important races. And Pat Fisher is running for the Ohio Supreme Court. So as is Pat DeWine. So the two Pats. And then Sharon Kennedy is running for Chief Justice of the Ohio Supreme Court. She would be replacing Maureen O'Connor, because she would then be vacating a seat. She would then, her seat would then be appointed by Governor DeWine, assuming he wins. And I think that's a safe assumption to make right now, but you know what they say about that. So I think what happens in November will play a large role in determining the outcome of this case, because that's four robes, right? And those folks will make a critical decision as to what happens with this legislation, whether it is ultimately enforced or not. I think you and I have talked about this privately, and also I'll make it public. It's also important for the Ohio legislature, folks who have been running on pro-life platforms, to get busy. I mean, if this heartbeat bill is ultimately defeated by the judicial process because of some of those portions of the Ohio State Constitution, it's important that contemporaneous with the legal battles that are taking place, that they engage in legislative battles to try to advance more enforceable legislation in order to support life.
Yeah, absolutely. So again, just to sort of recap this for everybody, we have a 7-member state Supreme Court. There's there's 3 members running or 3 seats open right now. And actually, if one of those wins for the Chief Justice, Sharon Kennedy, that's actually a 4th seat that becomes in place. So really in this election, the outcome of this case could be decided based off what judges get elected.
I would say highly likely.
Yeah.
Highly likely that this thing gets decided by what that court looks like. And so, boy, is it important for folks to get out and vote.
That's right. And I'll even say, I have behind me here one of our backpack bill promotional items we have. As we sit here right now in Franklin County Court, there's a lawsuit from the teachers unions and public school districts to completely abolish the state ed choice program. So, based on this Supreme Court election, whether or not Ohio has school choice programs, whether it's ed choice or the backpack bill, or whether or not Ohio has legalized abortion, will be decided by these state Supreme Court seats. And, as we're talking with folks about their voting and, making sure they turn out to vote, that's why we always say, make sure you get your voter guide, make sure you go to buckeyeballot.com and order these for your church. We have, I think, about 3 Sundays left to go before the election. And in these situations, it is all about turnout here. So, Brian, any idea of timeline of how long these things typically take to get up to the Supreme Court here as we wrap with you?
No. Yeah. I have no clue. I would guess that because it's such an important issue, I would think that the first district, once it reaches their eyes, they'll prioritize it. and try to accomplish issuing a decision relative to the trial court judge's order pretty quickly. But maybe first quarter of next year.
Yeah. Brian, somebody asked this question: Can a decision from this Ohio Supreme Court be appealed anywhere?
It could, yes. It can be appealed to the United States Supreme Court. But courts don't have to grant what's called a writ of certiorari, writ of cert, and so I would guess that they'll be unlikely to take up the case because, again, what they did was effectively level the playing field, and so now it's up to states to have it out. If this legislation gets overturned, then you run up the next legislation and you try to pass something that's more enforceable, that's maybe more deliberately responsive to some of the sections in the state constitution. You consider those sections of the state constitution that make this a little bit more difficult, and consider amending the state constitution in order to carve out a path. The battle is a marathon here, and not a sprint. So that's one of the things that Dobbs did for the state of Ohio and for all states that have majority members who believe in pro-life issues, that it leveled the playing field to basically go out and work to pass enforceable, effective legislation. And so it's up to the states now.
Yeah, absolutely. And I'll say a couple things on our side there, which is, I think, I think Solicitor General Ben Flowers and Attorney General Dave Yost have done a really fine job of arguing for us. And I think, I feel very confident that as long as we have judges on the Supreme Court that interpret the law instead of make the law, we will ultimately prevail here. The other thing, though, you mentioned something, and I see a question here from Michael about why don't we just go to the ballot and amend the Constitution to either say that ban abortion through the Constitution, or at least say that that there is no right to an abortion under the state Constitution, and clarify some of these things. I'll say those types of things are certainly within the realm of possibilities. This is speaking from CCV's perspective of, as we are looking at our strategy of how to protect as many lives, unborn lives, and protect women from the dangerous and devastating practices of the abortion industry. All of those things are certainly on the table as we're looking at the best way to do that. Quite honestly, if we can not have to go that route because it's so expensive, that's the preferred route, right? And especially if you can go legislatively, where we have pro-life lawmakers, we have a pro-life governor, we have we have pro-lifers all across the state that are willing to work through the existing systems to ban abortion. That's the preferable option to go. But we are ready and willing to do that if that's the only course of action before us. So Brian Fox, you've been gracious with your time, my friend. Thank you so much for touching base with us. And hopefully the next time we have you on, we'll have more good news. We had the great news and now the not so great news. But hopefully when we ultimately win this case, we'll bring you back and we'll have a good discussion then.
Democracy is a muddy business, and thankfully there are folks like you that are out there trying to make a difference in it. So thank you, and all that CCV does for folks who believe in life.
Hey, thank you, friend. We will we'll catch up with you later. We'll then bring in our good friend David Mahan now to turn topics to a different conversation and talk about the state school board. David, I see you're muted, so I'm going to spare you the issue of starting to talk and people can't hear you, because we've all been there on Zoom and been muted before. But we want to talk about, a lot of you have been seeing these headlines about things going on with the Ohio State School Board, right? So you have your local public school has its own school board. And then we have a state school board, which is a 19-member state school board, 11 elected, 7 appointed by the governor, or 8 appointed by the governor, rather. And this school board sets a lot of policy for our public schools. And there was a resolution that was recently before them that was making a lot of headlines. And they had a marathon session last week. And I will tell you, my friends, this honestly is why I'm so grateful for people like David Mahan, because David was in that hearing from dusk till dawn, quite literally, David. So David, can you just share a little bit about what was going on at the state school board? Why were you at the state school board meeting for so long?
Well, the school board actually was member Brendan Shea submitted a resolution, was to support parents in schools and districts in rejecting harmful, coercive, and burdensome gender identity policies. Basically, it was in response to a couple of things. One, the Biden administration, Department of Ag, started playing with Title IX, which was initially an amendment in 1974 to make sure that young ladies and women were not being discriminated against in education and athletics. And then what they're now doing to kind of kowtow to the gender identity cult is basically to say that sex is equal to gender identity. And so if you cannot say that women, so initially women were supposed to have their own separate facilities, women were supposed to be able to compete in athletics, that made it fair play for them. Now you have to include gender identity in that, and that's attached to different funding streams. So in this particular play, they now partner with the Ag department, who said if you do not, if you start discriminating with folks on the basis of gender identity, now you will have in jeopardy some of the free and reduced lunch benefits that about 700,000 kids receive in the state of Ohio. And so all of that was on the table. And so the state school board decided that they were going to kind of come in agreement with the Attorney General, Dave Yost, who basically said we're going to push back on this, in addition to about 21 other attorneys generals across the country. And then they submitted and put forth this resolution to do just that, to say, we don't acknowledge this play by the Department of Ag and the Biden administration, and we do come in agreement. And then there was some resolutions toward the end, to say that they did encourage the state legislature, the General Assembly, to support some of these things as well. So, yeah.
So just to add some more context to this situation, and let's just, I'm going to put it real bluntly and plainly. Basically, what you have right now is the Biden administration threatening to not give low-income kids food if their public school doesn't allow boys and girls sports and boys and girls bathrooms.
Right.
That's the baseline of this. That the Department of Agriculture oversees the free and reduced lunch program. So you have the Biden administration holding schools hostage and say, if you don't enact our transgender policies in your schools, and they're doing that by taking this warped view of Title IX. Right. If you don't do that, we are not going to reimburse you and pay for the food you give to impoverished children. That can't be overstated of how radical the Biden administration is on these issues, and the depths they're willing to sink to enact their social engineering policies. Again, this is, I'll just say, David, and you and I talk about this sometimes on our podcast, The Narrative, but a lot of times the left will say, well, why are these Christians so obsessed with sex? Why won't, and other people's lives? And it's like, what are you talking? You guys are literally trying to deny poor kids food if they don't adopt your crazy sexual revolution worldview.
That's right.
It's an incredible,
In the name of non-discrimination.
right, in the name of that. I mean, it is, and taking, you know, taking a law that was passed in 1974 and to suggest at the time to all my originalist friends on this call that they were thinking when they passed Title IX in the 70s about boys and girls sports.
That's right.
And quite honestly, they kind of were thinking about boys and girls sports in terms of keeping boys out of girls sports.
Fair play and safe play for females.
Exactly.
Yeah.
So anyway, so that's what was going on. So there was this resolution
Yes.
that they were considering. I'll just say the reason why a resolution like this matters. Now, most of the time at CCV, we don't do a lot with resolutions because resolutions tend to not have the force of law. We'll end up talking about the SAFE Act, David, which has the force of law. A resolution is kind of sending a message. But a lot of times with the state school board, resolutions matter because it's their way of communicating to the 611 school districts all over Ohio. Hey, this is how we are viewing the law, and this is how we think you should interpret it.
Right.
And so this was a resolution that you mentioned. Brendan Shea brought forward to say that, hey, school districts, we think what the Biden administration has done here is unlawful, also unconscionable, and we think it should not be enforced, and you should not go along with this.
Right.
But David, can you talk about this came forward? It sparked a big backlash. Can you talk about what happened at the state school board last week?
So there was a meeting last week. There was a meeting in September as well. There was probably in total about 150 people came in to testify. Seemed like in September they were more in favor or actually in opposition to the resolution. And then when I was there last week, they're definitely more in favor of the resolution. It was a three-ring circus. If you were to look at it from the outside, you would say, hey, there wasn't a whole lot of protesters out there. I wouldn't expect it to, I would expect to see more protesters. That's because all them jokers were inside. It was a mess. And so they kind of basically took over the lobby of the Ohio Board of Education. I was there from 8 a.m. probably to about 7:30. Public testimony started right after lunch around 1 o'clock. And the community really came out. We had several parents of children who struggle with their identity and who have been groomed in schools. That was a piece of this resolution, that children would not be able to be groomed by gender activists. And when you're hearing about all of these books that they're finding in schools and obscene websites that are all around the gender issue, they'll take down the website, they'll take out the book, but all the adult activists are still in the building, still in the system, still in the district. And they were out in force at the meeting. But our side of things did come out in force. We had Representative Reggie Stolzfus there, co-sponsor of Save Women's Sports in the House. We had Representative Click in there, the sponsor for the SAFE Act in the House, and both of them had strong testimonies. We had Dr. Weiss submit testimony, and they asked for him to submit a video, and then they didn't play the video. This man was an endocrinologist who actually performed gender affirming hormone therapies for several years and was the go-to for the transgender community in Northeast Ohio, and they did not play his video.
Who now opposes these things on kids.
Absolutely opposes these procedures, pediatric gender affirming procedures on kids, and testified in the SAFE Act. It was a great day all up until it was time to vote, which was actually on the schedule. After all of these hours, 8 hours of testimony, 150 people, it was scheduled for a vote, and it never really took place.
Yeah, and so I want to sort of pause, David, and we'll talk about what happened with the vote and where we go from here in a moment. But David, I want you to just talk about what you heard from the opposition and what they were saying. Because, I remember after that first hearing a few weeks ago, where the opposition to the resolution showed up. It's obviously, jarring when you hear some of them, but there was a part of it that I was actually glad that, for anything, for nothing else, I was glad we did these hearings, because you got to hear what the opposition said, and how radical their views are, really. And radical is, it's not a word I use lightly, but I use it because there's really hardly a better word to describe the positions of the people that were opposing this. So what were they saying up there that was really jumping out to you, that you feel like most people might not get? And let me also mention, again, if you have questions for David or for myself, please drop those into the chat, and we'll get to those questions.
Yeah, I would say one of the main things that really caught me off guard that I did not expect them to divulge was their denial of parental rights. I mean, they said kids are little adults. They were another issue was the suicide piece. If we don't affirm these kids, they will attempt suicide, and that even goes into parental rights. If the parent is not willing to accept who this child really is, then that child still deserves to be protected in schools. And so they need safe places and safe adults that they can go to outside the covering of their parents. That I did not expect to hear that as much as I did. I did hear a lot of the suicide myth that if these kids are not affirmed, they will commit suicide. One of the things I had to share in my testimony was, to the board, we have entire nations that are walking back their gender affirming therapy procedures, their pediatric procedures, after 30 years of performing them, not because they are Christian or socially conservative nations. We're talking about Finland. We're talking about the very secular London, UK. We're talking about Sweden, walking back. Matter of fact, in the UK, they shut down the largest and oldest gender clinic, and now they're being sued by 1,000 parents solely because after 30 years they cannot prove that these pediatric procedures, are improving the mental duress of these kids. And so when we are affirming kids in school, we are now complicit. We're not just being nice, right? We are now complicit in the first of 4 stages of gender transition, and that's social affirmation. And so I just wanted to make very clear that the schools knew that that's exactly what they were doing. And so a lot of the groups came up with, sad stories of kids that were confused, gender confused. And then after they were affirmed and had a safe place, how that improved their health. But one thing that we have to understand from the best research ever done, 320 gender confused individuals who actually went through all 4 stages of transition in Sweden, the largest study ever done, the most rigorous study ever done, over a 30-year period of time. So those that actually went through the surgeries showed to have a 19 times increase in suicide. Now, the thing that I had to make clear to the board was that was not realized until 8 years later. So yes, they felt affirmed. Yes, they were happy for a moment. Yes, they were feeling great from the hormones, the testosterone, which we call doping in athletics. Of course, you're going to feel good. But there comes a time right around that 8 to 11 year mark that the suicide rate increases. And we're seeing that more and more with the detransitioners. We actually did have a detransitioner whose her name is Helena. She's been on Tucker and Fox and all that. We had her on the SAFE Act here from the state of Ohio, around Southern Ohio area. She did come and testify of how she also got love bombed, but how that was not so much a positive thing. What all these detransitioners are saying is, why did you let me do this? I was just a kid. Why didn't you protect me from myself? And that's she really painted that picture well.
Yeah, no, it really. I will say, I think the thing that, like, I don't want to say I was grateful for this necessarily, but I'll say I'm glad it got out into the public, because it's happening. And a lot of times people don't believe us when we tell them that this is happening, right? That that the policies of schools right now, and actually the policies of hospitals as well, these gender clinics, is to keep parents in the dark, is to not tell parents about what's happening. They view parents as the enemy, not as the child's primary caregiver, and the one responsible for the child. And so I think it's very important. And again, this is why we're so strong on the backpack bill. This is why we say, listen, we think it's time to get our kids out of public schools, because there are ideologues in public schools and their policies, and they're using things like what the Biden administration has done here. They're using this as their justification for enacting these crazy transgender policies, to say, I can't tell a parent about what's going on with their kid.
Because they're barriers to service.
Exactly. And it is that serious right now. David, we just got this question from Michael, and I think this is the key question about where we go from here. There was a motion made. You mentioned there wasn't. It was planned to have a vote to vote on this resolution. That vote never happened. Instead, a motion was made that carried 12-7 to send the resolution to the executive committee. So what does that mean for the resolution, and where do we go from here?
Well, and I'm very passionate about this piece, but as member Shea and others pointed out, that this could be a move to kick the ball down the field, punt the ball down the field to kill time. Here we are mid-October. They only have a certain amount of meetings. They did ask that they would identify when these meetings could happen and when the vote could happen. They did not. And so they referred it to executive committee. And member Shea actually said, guys, if you vote to put this in executive committee, you are voting to kill this resolution. That's actually what he said. It is possible that they could, within the executive committee, that could be made up of just leadership, or it could be made up of the entire board. They could actually give this thing eventually a vote. It's just not likely.
Yeah. So I want to, and I'm seeing a number of questions kind of coming in about what do we do here on this state school board resolution now. So, big picture, it seems unlikely that this is going to get another vote. So the question is, what do we do? And do we invest our energy here? I'll say from CCV's perspective, we will continue. We work with state government. We're going to continue to put pressure to pass this resolution because it's an important resolution, and it is the right thing for us to do. And it really does send a good message. However, there is a bigger picture that would have a much more significant impact on protecting children, on dealing with these problems in schools. Because again, this is a resolution that doesn't necessarily have the force of law, right? And so when I say the force of law, it can't make anybody do something, right? Or they are breaking the law, right? In order to do that, you need to pass a bill through the General Assembly and then have the governor sign it, right? And so that is what we're trying to do with something called the SAFE Act, Saving Adolescents from Experimentation, which, David, if you can, it's House Bill 454. Can you describe real briefly what the SAFE Act does, and why, if we're trying to figure out what's the biggest impact we can have on this issue to stop schools from teaching these things and grooming children, as you said, and also stop children from being surgically and chemically castrated for the rest of their life by these transgender crazed doctors. What does how does the SAFE Act go about doing?
First of all, I want to be very careful just to let our listeners know that the SAFE Act only deals with 18 and under. We're talking about children here. In the media, a lot of times, and even in rooms like over at the Board of Education, they try to say, well, you're overstepping your bounds. The state does have an interest in protecting children, especially in matters of medical, what could be considered medical malpractice. We had an entire state, the state of Florida, the Attorney General's office said that these procedures being done on children are viewed as child abuse. And so what we need to do is say, okay, we've got 6 different gender clinics at least, and plus surgical centers, I guess, in the state of Ohio, that is actually stopping the puberty of children right around 7, 8 years old, giving them cross-sex hormones, testosterone for young ladies and estrogen for our young men. And then we do know, we have evidence that we are actually doing surgeries, surgical procedures, top and bottom surgeries on children under the age of 18. So in addition to stopping the grooming that is going on in classrooms, and you've heard us talk about what was going on with Cetero, with their Healthy Bodies, Healthy Futures over the years, putting all of these obscene LGBT websites out there to kids in classrooms for instructional materials. You've heard about the books, the curriculum, the speakers that are going in. It would put a stop to that, but it also puts a stop, make it illegal for the medical community, therapists, to push and drive kids and their parents into these experimental gender affirming therapies that many nations, as I mentioned before, are pulling back from after 30 years of just saying, listen, these things don't work. I do want to bring up one last point on the board meeting. The thing that really got under my skin the most, Aaron, was that we called in these mothers, we called in these professionals, literally doctors, risking their livelihood, mothers that are risking being outed by the media. The media was there all day long. They had to put up with a whole lot that day. Like I said, the protest was inside. I had mothers call me and text me at the end of the meeting when I got home around 8:30, saying that there were males, and I actually saw a male go into the female bathroom dressed, was in a dress and lipstick. But they weren't just going in there to relieve themselves. As the women were relieving themselves, they were just kind of hanging out like one of the girls. Like it was just part of their protest to be in there. Now, this kind of thing, I had 3 mothers that were followed to their vehicle by a 30-year-old, 40-year-old guy. And he didn't say anything, didn't put his hand on anybody, but just intimidated. Followed them to the elevator. They get on the elevator to the 6th floor, stops on the 4th floor. There he is to intimidate him again, just looking at him. They had to put up with all of that because they were promised there would be a vote. It was important. And for them to kick this thing down, you couldn't get 10 people on that board to say boys can't be girls, girls can't be boys, girls deserve fair play and safe changing environments. And just a few feet from the podium where everybody was speaking, we had biological males intimidating females and their daughters in the bathroom just feet away. If this is what's going on at the Ohio Board of Education, what's going on in all of these school districts across the state, they cannot be trusted in this area with our children. And so that's why the SAFE Act is so necessary. So we need to put all of that frustration, all of that energy into protecting our children through getting that piece of legislation passed.
Yeah, and the SAFE Act would do that by one, prohibiting these things from being taught in schools and requiring parents be informed about what's being taught. But bigger than that, prohibiting these procedures on minors, right? Prohibiting the cross-sex hormones and puberty-blocking drugs for the purpose of gender transition on kids.
Surgeries.
Prohibiting these surgeries. And that's honestly why, again, we're very frustrated that the state school board didn't act. We're still encouraging the state school board to act. They should. I think the big thing on this is that when you understand, as David just laid out, how devastating these procedures are, and when you understand these things are happening at Nationwide Children's Hospital, not far from CCV's office, the Cleveland Clinic, Akron General, Dayton Cincinnati Children's. When you understand how big this is, and then also that this worldview is being pushed in all 611 public school districts in the state of Ohio, you understand why we need to do everything we can at every turn we can to step up and push back, because we're literally castrating children.
That's right.
And that's why it was so wrong for the state school board not to act. But it's also why, if we're looking at where's the best use of our time and energy, it's to pass the SAFE Act. David, can you talk about where is the SAFE Act right now in the legislative process?
Yeah.
Why isn't this thing been passed yet? And what can people do to help us we got about a little less than 5 minutes left here. What can people do to help get the SAFE Act over the line?
Pressure. So last October, 1st of November, Rep. Click introduced the SAFE Act, House Bill 454. It has been sitting in that committee ever since. So we're looking at a year of sitting in the committee. The last few months, we had first we had sponsor testimony, and then nothing for months. And then right before they went on recess, we had three more hearings. Children's Hospital Association came in. Representatives from a couple of the children's hospitals across the state came in. They admitted that they are actually admitting kids into their gender clinics as young as 4, medicalizing as early as 7, 8 years old. And so we have had 4 hearings. The problem is we're running out of time in this 2-year General Assembly. And so, as you know, those of you who've been praying for a red wave, we've got one. Everybody that's anybody that matters is a Republican here in the state legislature. So we don't need Democrats to pass this bill. If this thing dies on the vine, it will be because of Republicans that are sitting on this bill. And I'm not going to name names because Aaron will fire me. But the reality is we need to apply pressure on the Families and Aging Committee, Human Services Committee, to give this thing hearings as soon as they get back. We don't need any more hearings. They just need to vote. But I think they're wanting to do one more hearing. If that's the case, then let's do it the week of the 18th and get this thing out. We've got the votes in the House. We need to get it to the Senate and then lame duck get this thing passed. And so we just need you to contact, if you go to our action alert at ccv.org /the-save-act, it will actually get you to an area where 5 minutes you can email all 17 members of that committee, and we can get this thing done. We've been running all across the state, preaching in churches, preaching in groups. I've got 3 groups this week, was in one this morning. People are appalled when they find out what is going on under their noses, under Republican leadership in the state of Ohio. They were appalled. But the question is, how many will take that okay, I'm disgraced by this, I'm upset by this, I'm enraged by this. How many will turn that into some action and let these folks know, hey, we're not for this. Our eyes are on you. You're not going to be in our district talking about how ridiculous it was that Leah Thomas won the NCAA, in Georgia, and how we have 6 clinics, stopping puberty, chemically castrating children, physically castrating children, and you do nothing. So we need you to act and act now.
Yeah, and I'll say some names for you, David. Just so I'll say Speaker Bob Cupp.
That's right.
And Chairwoman Susan Manchester, both from the Lima area, who the bill's fate lies in their hands. Whether that committee gives it a vote and whether it's brought to the floor. And again, I see more questions coming in about the state school board. And by all means, my friends, if you feel like you want to call the state school board and express your frustration and encourage them to pass this resolution, I say do it. But if you want to see these procedures stop, I cannot emphasize this enough. The most important place for you to put your energy is at the General Assembly, because this is the difference between a resolution and a bill, right? We pass this resolution at the state school board. It sends an important message, and it supports what will eventually be litigation over this Title IX issue, right? This is one aspect of this transgender policy, Title IX issue that the Biden administration is doing. But it won't do anything to stop children from being chemically castrated. And it actually won't do anything to stop schools from teaching this, right?
That's right.
It doesn't ban it under state law, right? The state school board is not ordering schools to stop doing this, and they really couldn't do that, right?
It's a local control state.
It has to be the General Assembly. And that's why we're putting so much of our energy behind House Bill 454, because this is what we talk about all the time at CCV. We want to focus in on the big picture issues, the things that'll have the biggest effect, and help focus the body of Christ there. And so, as David mentioned, go to ccv.org. You can use our action center there.
It's in the chat.
It's in the chat as well. I will just say, we just hit 3:00. We thank you so much for making the time to join us, along with going to the SAFE Act, to ccv.org to send your message on the SAFE Act. Also go to buckeyeballot.com and order voter guides for your church, so that they, these are free resources we provide. This is one of the few election resources that's 501c3 friendly. We survey every candidate and report back to you where they stand, even on issues like the SAFE Act or the backpack bill. It is up to the body of Christ to have a voice in this election. This gives you information, even on those state Supreme Court justices we were just talking about. You can order these, they're free. We'll get them out to you right away. We only have about three Sundays left before that November 8th election. And it is so important that we turn out to vote. So please, if you have not yet ordered your voter guides, you can get those at buckeyeballot.com. You can also get a personalized voter guide there as well. David Mahan, Brian Fox, thank you so much for being gracious with your time. Thank you to everyone who supports Center for Christian Virtue, for your prayers, for your action. We are always here to serve. If you have more questions, feel free to reach out to us through our website, ccv.org. And we'll be back again next time. There's more breaking news for us to share with you. Also, too, you can always go and download David and Ma's podcast, The Narrative. We had a broader conversation about the state school board in this most recent episode that we just posted on Friday. And that's where, just on a near weekly basis, every Friday, we'll have sort of news updates and then great interviews for you as well. So we're grateful for you, and we'll see you again next time here at Center for Christian Virtue.